And if I speak slowly, I might forget things. But anyway, so I think I'll try and reduce my pace. If at any point you feel I'm too fast, you let me know so that I can tone down, so that I don't lose anyone or leave anyone behind. So I'm going to try my best to make sure that we are all moving at the same pace and we are all able to capture as much information as possible. Now, this is criminal, and when it is criminal, please remember that the most important factor is for you to understand the content, okay? I always insist on the content, because I know that if you know the content, you don't have to go cramming case law. You don't have to cram the various sections of the CPC or the Penal Code or the Sexual Offences Act. You don't have to do that. So just make sure that you are understanding the content. And the content really means the concept. If it is about bail, you should be able to know bail to the extent that you can explain bail to a friend. Okay, you can tell a friend about bail. What is this thing called bail? Do you understand it? Where did it come from? Why do we have it? What is the basis of bail? What are some of the things the court will consider before granting someone bail? Okay, so you need to understand that point also very well. So if you do understand that, it becomes easy for you to maneuver through and answer the question. The next thing that I might also want to mention is that, guys, my memory is very good. You might not believe it, but I know everyone who was paid for this class. Everyone, every single one by name. So you know what to do.
Sure.
Okay? Yeah, so you know what to do. So if you're in this class and you know you're here illegally, I'm going to project your name. And if I project your name, I will even project the name of your people, so that your people can see how you're doing. All right, so let us pick from the last class. And in the last class, we talked about the question of the introduction to criminal law. And I gave you guys an assignment that I would not wish that you ignore. Some of you are very good at ignoring the assignments. And I gave some few assignments in the last class. The first one that I gave is really just read the Evidence Act, specifically on the question to do with production of evidence. The second assignment I gave is, if you don't already have it, please get a copy of your Constitution. It is very important that you understand Constitution as a law student. So read Article 49, Article 50, and 157. Those are the only things I told you to read. It doesn't take much of your time for you to go through and read and understand what is in the Constitution and the articles. And then please take your time and then understand it. Okay? All right. So please, those are the two assignments I gave in the last class. So in the last class, we introduced criminal. And in terms of introduction, we talked about the general principle of criminal law that you might have gone through in your undergraduate. In your undergraduate, okay. So in your undergraduate, you might have gone through the principles of criminal law. So you want to have them at the back of your mind. Okay. So if you do that, it is easy for you to run through and relate. All right. Now, we also introduce the question of arrest in terms of who conducts an arrest, in terms of how do you arrest somebody, in terms of what are the modes, the two different types of, modes of effecting an arrest. And also we discussed the instances when somebody can be arrested with a warrant and without a warrant. You need to understand those two aspects. And then also we talked about the question to do with the Constitution, which is the rights of an arrested person. That is Article 49. We talked about that. Now, a concept that we introduced but we didn't complete is the one under Section 36A, where we talked about the First Amendment to Section 36, which is 36A, in questions to do with remand by court. So we are going to include it under the topic of investigation, which I want us to do right now. I want us to do that right now. So as we discuss the topic of investigation, I want you to understand and have at the back of your mind 2021 of June question 1 and also the November of 2021 question 1 somewhere at the back of your mind, because it will help you understand the question of investigation, okay, which traditionally they used to call the preparation of files. Okay, so that is what we are talking about. So please stick around. Now, before we get to that point, I first want you to understand what we are calling the criminal procedure. Now, there are two things in terms of criminal law. The first one is called the criminal procedure, and the second one is called the trial procedure. They're two different things, but the trial procedure is right within the criminal procedure. Now, at the back of your mind, please make sure you know the criminal procedure. Okay? Where do you start from and where do you end? Okay? So I'm going to explain or give you a summary of the criminal procedure so that you understand it and have it somewhere at the back of your mind. Why am I saying that? I'm saying that because when you get a question, that question is going to be pulled from a specific stage in the procedure. If you're being told that your client has been arraigned before the court, then you need to understand at what stage is that coming from and what is supposed to happen at that stage. If you're being told that your client has been put on their defense, at what stage of the process are we speaking? Okay, so once you understand that, that is the basis of understanding criminal law. Okay, that is the basis of understanding criminal law, because trust me, most of you would want to pass this unit criminal law, or most of you would want to become criminal lawyers, or most of you are lawyers and advocates in making, but they can't explain to a layman what is the criminal process. If your client has been arrested, a friend of yours has been arrested today, okay, and they're asking you, so what next? You need to understand or to connect all the dots from the point they're arrested until, okay, until the point they're free or until the point they get to committee. So I want you to understand that process is a very holistic process. Have it at the back of your mind. It is not complicated. Are you together? It is very simple. And if you just have it at the back of your mind, it will help you understand. So the very first thing is normally a complaint. The first thing is normally a complaint. Are you together? The first thing is normally a complaint. Somebody is saying something. I don't know what they're saying. Can you guys hear me?
Yeah. Yes, Jacktone.
We are hearing you, Simi.
All right, so the complaint. Somebody's microphone is on. Okay, perfect. Can you mute that thing? Okay. Who is that? Maru, Isaac. You have a question?
Sorry, it was by mistake.
All right, so a complaint. So that is where it all begins. There must be a complaint. Now, this complaint can be recorded or it can be noted. Okay. First thing, you can record it at the police station. You can go to the police station and say something has been stolen from my house. That is a complaint. Or sometimes there needs not to be a complaint for you to be arrested. Okay. We will just see what you're doing. We will arrest you. We go and record in the OB and then we proceed from there. So the complaint can come either before arrest or after arrest, or even during when you at the time you're being arrested. So the first thing is a complaint. A complaint is whereby the allegation that something happened. Somebody walks to the police station and they indicate to the police that something happened to them and they're alleging that a criminal offense might have been committed. So make sure you understand that bit. All right. So after the complaint, what normally follows is the investigation. Now, the rule is very simple. You go and investigate and then come back. Don't arrest first. Go investigate and then come back. That is the normal rule. That is a simple rule that is required in law, that you complain, you investigate. So under investigation, this is where you're going to look at things of ID parade, preparation of files, effecting an arrest. All those will fall under investigation. And then after you investigate, depending on the circumstance, the person is apprehended if they're not already apprehended. And then the next thing that happens after investigation is what you're calling the decision to charge. Now, the third step is the decision to charge. What is the decision to charge? The decision to charge is whereby we are picking the file. Once the police has completed the investigation process, they compile the file and the report. Now that report is sent to the DPP. Why are we sending it to the DPP? Because of Article 15157. What does it say? It indicates clearly that it is only the DPP that shall have the right to institute a charge against anyone. So the file will be carried by the OCS to the DPP. And remember that almost every station has the office of the DPP. A good number of them. Okay, they have the DPP's office within the station, or at least the prosecutor's office within the station. So it is easy for them to coordinate. So remember that the file must be taken to the DPP. Okay, once it is taken to the DPP, then the DPP will be deciding whether they want to charge. So in terms of decision, they have to get through what we are calling the evidentiary analysis, the factual analysis. So they have to analyze the file before they decide that they're going to charge. Now, if you log into the ODPP website, don't have to log in, just browse on it. You will find a document called the decision to charge policy. So that policy is the one that governs the ODPP in deciding whether they should bring a charge or not. So the first thing is the evidentiary threshold. Okay. So for instance, if there's a question about murder, that somebody has been accused of murder, he has been arrested. You as the DPP, what are you going to be considering before you charge this person? What piece of evidence are you going to be asking for? Okay, welcome, Mikono. You are the DPP. You're the prosecutor after you're admitted to the Kenya School of Law. I mean, to the as an advocate, and you have a file before you. This file is from the police. They are saying that person XYZ has been accused of murder. Now, what is the first piece of evidence you are going to be asking the police to give you before you proceed and decide or ask for other evidences? Someone. Caroline Wahoo.
The victim, the person who has been murdered.
Exactly. That is a main piece of evidence. So there must be a dead body. So the dead body must be there. If there's no dead body, there is no murder. There is no murder without a dead body. Okay? So the first thing you're going to be asking is, where is the dead body? So it means if the dead body is not there, then we are not going to institute any charge. We are not going to institute any charge if there is no dead body. Okay, so that goes to the DPP. That goes to the DPP, and then the DPP will decide whether they want to institute a charge or not. Okay, it's very important. Now, after the decision to charge, the DPP will make a decision to charge. So they will bring a charge. Okay, the person will be arraigned before the court. Now there's arraignment. So the decision to charge, the fourth thing now happening is now the arraignment. Guys, there's a complaint, number one. Number two, there's investigation by the police. Number three is the decision to charge by the DPP. Okay, after that, you come to the question of arraignment, which is under Article 49 1F and 1F and G. Now, under arraignment, the suspect is being taken to the court, the nearest court with jurisdiction. Now, remember, in criminal law, we don't have geographical jurisdiction. We don't have it. If somebody is telling you that there's a geographical jurisdiction in criminal, it's not true. Now, the law as it is does not bind authorities or the DPP to a specific place they have to charge you in. Okay? Why? Because generally criminal law is seen as the power of the state. So you can exercise it any place within the borders of the country. However, in civil, there's something that is very serious that is called geographical jurisdiction. So a court in Eldoret can only handle matters happening in Eldoret. If it is a court in Kisumu, just in Kisumu. But in criminal, they can arrest you in Busia border, they'll charge you in Mombasa. Essentially, they're not supposed to do that because it affects your right as an accused person under the Constitution. Because if you're living in Busia and maybe it is you've never even gone past that Busia itself, if you're presented before Mombasa court, how do they want you to survive? Okay, it will affect your right as an accused person. So it is just right and advisable that when you're arrested in Busia, you be charged in Busia. But nothing stops the DPP from charging you in Moyale. They can do that. They don't have any limitation as per the geographical locations. But for good practice and order, they make sure that the accused person is charged within their location or where the crime was committed. Are you together? So that is also, and you've seen this happening a lot of times. You've seen even governors of different counties being arraigned before a court in Nairobi. Why? Why should they be brought to Nairobi and they have their own counties? You've seen politicians being arrested somewhere in Mombasa and they're being brought and being charged in Nairobi. They can do that. So most of the time, the DPP will use that as a way to punish you. They just use that to punish you. Of course, again, the law is still very weak in terms of geographical jurisdiction, so you can't pin them down on that. But again, for good order, you'll be charged or arraigned before the court within the jurisdiction of your location. So that is arraignment. So under arraignment, what you need to understand about arraignment, and this is, I want you to understand it holistically. Okay. Now, under arraignment, the law is very clear. What is the law saying? That on the first court arraignment, when the suspect is arraigned before the court on the very first day, certain things are supposed to happen. The first thing that is supposed to happen is that they're supposed to be charged. Okay. You already know they're supposed to come to court within 24 hours. Okay. And when they're brought to court within that 24 hours, unless the 24 hours are falling out of the normal working day for the court, then on the first arraignment, there are 3 rights. Okay, these 3 rights, remember them, because they will inform our discussion under section 36A. Now, the first right is the right to be charged. Okay, the right to be charged. You, I think on the media 2 days ago, 3 days ago, this week, there have been Jimmy Wanjigi, that is the first person that was arraigned for charges. And then there's that lady Aoko, a very crazy person. So that one also. So you saw they were not ready to release her last week, even though she was arrested within the working hours of the court. Okay, so you are not supposed to be brought before the court within 24 hours. So if the 24 hours will lapse out of the time, the court time, then the next available date that the court is sitting. Now, when you are arraigned before the court, then the rules are very simple. There are 3 rights. The first one, you have the right to be charged. Now, when you are brought before the court, what is the meaning of you have a right to be charged? They arrested you because they said you did something. Now let them charge you with that thing. That is what you're calling the right to be charged. That is the first one. The second one is if they're not charging you, let them release you. Let you go home because they don't have anything against you. Number 3, if they can't release you, they can't charge you, then they have to tell you why. You have a right to know why they're being detained. Why you are being detained without a charge. And that will bring us to remand by court. I'm coming back to it. So you've been arraigned before the court. So once you're arraigned before the court, the next thing that happens is the plea. Okay? The plea. The charges are read. You're charged. Okay? You're charged, and then you plea, and then you get the pleas recorded. So arraignment and the 3 rights, including the right to charge. So assuming that you're being charged, then you will get charged. So under the charge, that is where they read you the charge, the substance of the charge, and the mistake you committed. Okay. Once you get of course you get to get your charge. Of course, the prosecution and the court will read the charge and they say so and so you've been accused of doing this and this. How do you plead? Okay, that is the charge. Now, after the charge, you are supposed to plead. Okay, you're supposed to plead. So the plea will come under or after charging. So under the plea, what is supposed to happen? You're supposed to answer to the charge. Yes, I did it. No, I didn't do it. Or you can remain silent if you want. Okay, so you plea. But remember that before any person takes the plea or gives the plea, certain things the court must do. The first thing is a mental assessment. We have to confirm whether you are mad or you are not mad. Now, we said in the last class that don't call that person a mad person. They are not mad. Okay, mad is not a legal term, because if you dare say that in an exam, the examiner will also be very, very, very mad. The marker will be very, very mad. So the person is a person of unsound mind. So the mental checkup. Number 2 is the question of understanding whether you understand the language of the court. You understand the language of the court. If you don't understand the language of the court, which is English in the High Court and Kiswahili and English in the Magistrate Court, they will bring for you someone from Nyamira or from Kisii. Most translators are Kisiis. I don't know why. They're experts. That is their field. People from Nyamira. They're translators. They're the people that will be translating. I don't know why. I've done my research into how the number keeps going up with Kisiis translating. But anyway, maybe most of them don't understand the language of the court. But if you don't understand the language of the court, depending on which court you are supposed to get someone to translate for you, free of charge. Okay, that is number 2. Number 3 is whether you need an advocate representation. Can you afford an advocate, or is it a case that you need an advocate? Now, after that, then we go and talk about bail. So that is bail. So you get bail or get denied bail. So after the bail process, then we go to the hearing stage. The hearing stage. Now, before the hearing stage, we might have the pre-trial. Okay, and then the trial. So you are arrested. There's a complaint. Once the complaint has been recorded, you are arrested, and then investigations. Decision to charge by the DPP. After that, you are arraigned. You are charged. You take the plea, and then bail. After bail, we go to the hearing stage. Now, at the hearing stage, 2 things happen. The first one is the pre-trial. The pre-trial is just the pre-trial conference where both parties agree on some preliminary issues. After that, we get straight into the trial process, which is from section 208 to 211 of the CPC, the trial process. The accused person will go second and last. So the prosecution will start the accused person, and the accused person will close. And then after that, we'll have judgment. We'll have judgment that comes in two forms. We have a conviction and an acquittal. After judgment is out, we will have what we're calling the sentence. Now, the sentence is the punishment. Judgment is the answer. What is judgment answering? The judgment is answering the charge sheet that yes, you did it, or no, you didn't do it. And then the sentence is the punishment to the judgment. Did you do it? Yes, as per the judgment. Now, the punishment is the punishment you get. The sentence is the punishment you get for doing it. Okay? That is the sentence. So after sentences, we have three things. The first one is appeal, we have revision, and then we have retrial. And that is the end of the criminal process. So please have it at the back of your mind because it is very important. Very, very important. If you don't understand that bit, then we cannot even move forward with this class until you understand it. Okay? Until you understand it, we can't even move forward with this class because it is going to be very hard on you. You will not be able to understand where we are coming. Oh, sorry. You'll not be able to understand where we are coming from or where we are going to if you don't understand it. So is there any question? Now, let us go back and discuss what I wanted us to discuss today. Okay? The first thing, I can't see any hand up. If there's a question that we're going to discuss later, you can suspend it and then we discuss it. If it is something that is ahead, I'm just highlighting for you so that you know what we are going to cover and where we are. Okay? Jennifer, what is your question?
My question is, under arraignment, you say that since it's the state, they have the power to charge you anywhere. So I'm asking, does the court have the discretion to decline to charge you? For example, if you're being charged in Mombasa and you're from Nairobi, does the court have the discretion to decline?
That is, like you say, it's a discretion. The court can decline no. The court has the power to say no. The court can say, hey, you guys are punishing this person. Take him back to Busia so that he can be charged there. Yes, the court can. You saw even in you saw in the case of Miguna when he was presented to Kajiado. The court in Kajiado said, take him back to Nairobi and charge him there. So generally they can decline jurisdiction, but there is no specific place where that is coined that it must be in the same place. It is just a matter of order and administrative convenience on the side of the accused person. So if the accused person is not complaining, well and good, we proceed. If the accused person is complaining, we have to take him back to where he came from. Yeah.
Okay, sawa sawa.
Okay, so let us go back and talk about the question of investigation because it's very important. So up to there, we have said there's a complaint. So after the complaint, we come to investigation. Now, there are a lot of things that get inside or get into investigation. So investigation is a lot of things. The first thing that will go into the investigation is the preparation of files. Preparation of files. Now, under this one, I want you just to understand what these files are. What are these files? Now, remember that at the end of the day, the police must give the DPP the file. Okay? At the end of the day, the file must be taken to the DPP. Okay? Because the DPP doesn't do anything. The DPP doesn't do anything. If there's a section of lazy public servants, is the DPP. Those guys don't do anything. They can even decide not to speak in court. And they will still earn their money. They don't do nothing. They just sit there and say, nothing further, Your Honor. We shall proceed with the file. So they wait until the police will do the investigation and then they get the file. That is all they do. Okay. Once they get the file, they adduce the evidence and then they're done. They wait for another file. So it is that easy unless they have a vested interest or is a political offense. Okay. Now, So what goes into investigation? The first one is the preparation of files. Now, I will give you an example so that you understand what preparation of files really entail. So the first one is that somebody has made a report that someone has been assaulted, or let's say a shop has been robbed. So what will happen? The first thing the police will do is they will proceed to the scene. They go to the scene of the crime. So once you go to the scene of the crime, they secure the scene. And then everything they do after that will form part of the files. Okay. The first one, they will take the scene photographs. They'll take pictures of the scene photographs. They will retrieve any electronic or documentary evidence like the CCTV feeds from that shop, if there's any. They will collect any exhibits that have been left behind by the thieves. Okay, collection of the exhibits. They will question eyewitnesses. They will record statements from the witnesses that are there. So all those things will form part of the police file. So the police file, or what we call the prosecution file, because it is the police file that will graduate into the prosecution file. So when it is still in the hands of the police, it is the police file. Once it exchanges the hands and then goes to the DPP, it becomes the prosecution file. Okay. Now all those things will go into the file. So we have the scene photographs, we have the documentary evidence, we have the exhibits, we have the witness statements, all that. That forms part of the normal investigation that will happen. So they will just go to the scene and do whatever they normally do. Okay. If it is a gun violence or there was a shootout, they will collect the cartridges that have been left behind. Those are exhibits and everything else. They'll take pictures. They'll question any eyewitness that is around, and they will explain why or how they saw things happening. So all those things, they will put that in the file. And then after that, they will make apprehension. They will arrest the suspect. Okay, they will arrest the suspect. So once a suspect has been arrested, then they will take the statement of the suspect, which also goes into the file. The statement of the suspect will also go into the suspect. Into the file. So really, when you talk about preparation of files, it is simply the procedure of conducting investigation. So everything else that you call, that you do during the investigation, it must go into the file. And then of course, after the entire process, once you're done with the investigation and you write your summary, then that investigation summary will still form part of the file. So preparation of file is not hard. It's just everything that is being done by the police during investigation. So you could get a question like 2021 of June and November, that how can you be of help? A shop was stolen. So a shop was broken into and some things were stolen, and the police are at the scene. How do you think you can help the police in that instant? That is a question simply asking you about preparation of files. So there's question of taking scene photographs, recording statements, collecting exhibits. Those are the things you can do to help the police, and that is the process of investigation. You can prepare the investigation brief, all those things, which will go into the file. So when you talk about helping the police at that point of time, then you just know it is a question of investigation. And that is why I'm saying, and I'm repeating again, at all times, know the stage. Know the stage. Where are you? If you don't know where you are, you can't know where you're going to. So first ask yourself, in the entire criminal process, at what stage is this? Is it investigation? Is it charges? Is it plea? Or is it judgment? So once you know which stage it is easy for you to handle. Okay. So that is 2021 question 1. We will look at it, and those 2021 November question 1. They're almost two similar questions. Okay. That is the CLE paper. So again, understand that. So once we are done with preparation of files, regardless of the order, the most important thing is know what goes into that file. So everything else, because remember, you can get a question telling you that this is what happened, this is what happened, this is what happened, this is what happened. So please proceed and prepare the files or what will go into the file. So you just go to the question and ask yourself whether there's the photographs, the recorded statement, documentary evidence, electronic evidence retrieved, if there's any what you're calling the exhibits, all those things, they'll go into the file. So that is what you're calling the police file. Now that file will graduate and become the prosecution's file. Okay, it will graduate and become the prosecution's file. And then the other file that we're going to have is the advocate's file. So everything else, remember guys, everything else that is in the prosecution's file. Now, once it graduates to the prosecution's file, what are they going to add to it? They will add a charge sheet or an information if it is a high court. So everything else, the moment it gets to the DPP, they will add a charge sheet. If they've decided to charge, it becomes a charge sheet. Okay. Now, all that information will be photocopied and given to the advocate of the accused person, to the advocates of the accused person, and therefore that information will also be in the advocate's file. So the advocate's file is the advocate of the defense, or that is the defense counsel, that is the accused person's advocate. Everything it has will be gotten from the prosecution's file. And then the same thing, everything that is in the prosecution's file will also be photocopied and given to the court, and that will form the court file. So the prosecution's file, which sometimes is the police file, the advocate's file, and then the court file, they all contain the same thing. There's no file that is having a different thing because we are prosecuting one person, so every document must be the same. So that is the question of preparation of files. Any question? No question. Okay, so if we don't have a question, then I want us to go and talk about something else. And that something else is still within investigation. Okay, it is still within investigation. So we are done conducting the initial stage of the investigation. We are now talking about preparation of files, which we have already prepared by the police. It is still with the police. The next thing that will come is what you're calling now the apprehension, that is arrest, which we already discussed. I'm just connecting it. So at some point, the arrest is being done after investigation. And most of this happens with a lot of corruption cases. You don't just wake up and arrest somebody. You do some slight investigation. And this investigation could be years and years long, or it could be minutes. Okay? The police can do the investigation in minutes, and then they make a decision to arrest you. Okay? So that is their power. So arrest is part of investigation. Why do they arrest you? They arrest you so that they can question you and ask you some questions and grill you a little bit. That is part of why they're apprehending you, so that they can ask you questions, you can record a statement with them, and then they can decide what to do with it. Okay, so that is still part of investigation. When they arrest you and they are trying to get questions or admission or anything from you, then that is still part of investigation. The next thing also is what you're calling the ID parade that I want us to go into. The ID parade. Now the ID parade is still part of investigation. So remember we are discussing investigation, and I've said there's certain things that will form part of investigation. Okay, certain things will form part of investigation. The first one I've said is normal preparation of files. Preparation of files will come from the police proceeding to the scene of crime and then collecting each and every bit of information and putting them in the file. Okay. At the same time, remember that the investigation process that ends when the file is presented to the DPP will include a lot of things. And now everything will be concluded when the file is presented to the DPP. So that file will keep being built up, revamped, slow by slow, until every information is there. So we have preparation of files, which is ongoing. We have the question of if the person is not yet arrested, they'll be arrested. So that is apprehension at the same time. And then we have the ID parade. Now, ID parade is not an important part of investigation process. It is not an important part of investigation, only if it is required. So that gives us ID parade. So let us talk about ID parade. So what do you understand ID parade to be? Okay, the identification parade. Now remember, when a criminal when a crime is committed, there are two things that are very important to the crime. In the eyes of the law, there are two things that are very important. The first one is the evidence of commission. Okay, the first thing that is very important when you're trying to prosecute a crime is the evidence of commission. Where is the evidence that something was committed? For instance, if there's murder, what is the evidence of murder? So the evidence of commission of a murder is the dead person. So there's already a dead person. Number two is a positive identification. It is not enough that you found a dead body by the road. You can't bring a charge. Okay? You can't bring a charge. Just by finding a dead body by the road, you can't bring a charge of murder. Why? Somebody tell me why. It's a very simple thing. Please don't think out of the box. Just remain in the box. You are the police officer. You are the police officer. You find a dead body by the roadside. Do you directly go to the DPP and then you charge? You bring a charge of murder. Mwanyale Priska, what do you have to say?
I don't think you can automatically say it is murder because one, you need to know the cause of death.
Fine, you're thinking out of the box. Me is a good thing, but for this one, I want you to stay in the box. So you know it is murder. Okay? How do you know it is murder? Because maybe it was committed next to your house and you are hearing somebody saying, don't kill me, and then you had a gunshot. And then when you go to the scene of the crime, you find somebody that has been shot dead. So you know definitely that is nothing aside from, so it is murder. The person was murdered. So why can't you just bring a charge of murder? Rachel Omondi.
The charge has to be brought against someone. There has to be a suspect who had committed the crime.
Exactly. Thank you. That's why I'm telling you, don't think out of the box. It's a simple thing. So who are you charging? That's the question. Fine, it is murder. You had somebody being murdered. Who are you charging? So the most important, when the person is not there, when there's no suspect, there is no offense. Okay? You can't charge anyone with anything. Who do you want to charge? So you must find someone to be responsible for that crime. And that is why we are saying there are two things that are very, very important. The commission of the offense, which carries two things, the actus reus and the mens rea, number one and number two, and also the suspect, the positive identification. That is why at all times, if you are prosecuting, there are two things you have to demonstrate. The first thing you must demonstrate is that an offense was committed. An offense was committed. Number two, you have to tell us by who. Positive identification. Not that you're thinking, I think it's this person. No, you must have positive identification. Now, how do you get the positive ID? Either you saw them, you have an eyewitness that saw them, you conduct your DNA, the DNA test, or you have maybe a CCTV camera somewhere that captured them doing that, or they confess that they did it. Are we together? So there must be a positive ID. A positive ID. Now, in the instance where you have arrested the person, okay? You've arrested this person, you've conducted other sides of investigation, preparation of files, but you are not sure of the ID, then you proceed and conduct the ID parade. The ID parade is only conducted where it is needed. Okay, why do you need ID parade? ID parade is needed so that you can establish a positive identification. And that is why the most rampant question you'll hear in a criminal court is, J. No, Swahili is not my thing. Can you see the person that assaulted you in court? Okay. And then the victim will be saying, yes, namuona. Ako wapi? Ndo yule. That is ID, identification. So that must, if there's nothing of that sort, then there's no person to be charged. Okay. So ID parade is part of investigation, and it is only part of investigation if it is required. And that brings us to the first thing we're going to discuss. But guys, don't lose the track. And I want you to not to lose the track. And what is the track? The track is, in the last class, we introduced criminal law. This is the law of crimes. This is the law that ensures that criminal offenders, the goons that have been hired to sabotage the economy, are being brought to book. Okay, that's criminal law. It ensures that people get punished for their offenses. Are we together? Now, if that is the case, then we came and discussed now the first aspect of it, which is now the question of investigation. So the complaint and then investigation. Now, under investigation, we have said we must get some information about this case. And through getting that information, we will end up making some files or preparing some files or some information. Okay? And that is an ongoing process until the file is submitted before the court, including the last document. The last document to be in that file should be a charge sheet. However, the parties can seek, okay? The parties can seek, that is the DPP can seek to add additional evidence as time goes. Are we together? So, preparation of files, of course, arrest. The person must be arrested as part of the investigation, okay? And then we have ID parade if we need the ID parade. So the first thing you need to understand about ID parade is, number one, when ID parade will not occur. When the ID parade will not occur, put up your hand. That is the first thing. As I mentioned them, as I list that down, put up your hand. So when is the ID parade supposed to happen, or when is it not supposed to happen? That is the first one. Number two, the rights of the suspect. The rights of the suspect during ID parade. The rights of the suspect during ID parade. The third one is what happens before ID parade. What happens before the ID parade? And then what happens during the ID parade? And then lastly, what happens after the ID parade? And then finally, we shall talk about the admissibility of Form P156. Form P156 is the form that will indicate the proceedings of the ID parade. So let us start. When do you think ID parade will not be conducted? Yes, welcome Mikono Juu. Guys, ID parade, I'm very sure that you guys have done this before and you guys are well informed. You have relatives who are criminals or relatives who've been arrested, or even yourself who is a criminal you've been a visitor of the state. So you might have seen ID. Rarely do they happen though. Not so much. They don't happen anyhowly. But I'm very sure you have an idea of what it is. If you watch movies, you might have seen it somewhere in a crime documentary, whatever. So let us start with somebody called Dagane Aisha.
Hi, good evening.
Good evening.
Okay. So one of the instances where an ID parade will not be conducted is if there's lack of consent from the accused.
Yes, that is the first one. So very, very important. The accused person must consent. The accused person must agree. If they don't agree, there is no ID parade. Okay. Let's go to Zaweria. Zaweria.
The witness is known to the suspect,
Yes.
probably a wife, a friend.
Yes, if you already know the person, there's no need of wasting time. You know them. So if you know them, you will indicate in the statement that the suspect is well known to me. The person that assaulted me is well known to me. So if they already know each other, they're friends, they're workmates, they're colleagues, they're spouses, we don't have to go through the ID process. Okay? Thank you. Let's go to Dami Abdul Kadir. Abdul Kadir. Abdul Kadir is not there. Baji Barako.
When it is impossible to find 8 people with the same features as the accused person, as the suspect.
Yes. Yes. So if it is impossible for you to get at least, the rule is very simple that you must have at least 8 people of almost similar physical features as the suspect. Sometimes it is very hard for you to do that. So assuming, for instance, Wajir, if you're in Wajir County or Garissa or Northeastern, and someone from Western Kenya, maybe Wanyama or someone, has been arrested there in Northeastern, or Wajir, and he's been lined. You know, those people that come from the north, they always look alike, all of them. There's a way they look together. If that is a word, they look together. Okay, so you can't, unless you know them personally, you can't tell who is who. So if you line them with someone from Western Kenya, of course, from a Western, someone from Western Kenya, you just know this is someone from Western. So you will be the odd one out. Or someone from Northeastern has been arrested in Busia or Kakamega. So if you line 7 lawyers with this guy, they will know that this is the odd one out. So you need to eliminate the chances of them being the odd one out. So it means if this person is from Western, you must get at least other people that look like they're from Western. Okay? But I think Western people just look like themselves. I don't think there are people that look like Western people. They just look like themselves. So you can't even hide it. If they're coming from Narok and they have the Maasai things, make sure you're getting other 7 Maasais. Okay? If they're coming from the coast, if they're light-skinned, get others like that. They're coming from Kisii, the same way. Okay? So the rule is very simple. Why do you need to do that? Is it discrimination? No, it's not. It is ensuring that you reduce chances of guesswork. Okay, so you must, so if you can't get the 8, then there is no ID parade. Lastly, Priska?
Where the witness cannot identify or recognize the suspect, cannot
Yes.
easily.
Yes, so remember the rule again. Before the ID parade, we are going to talk about that. The witness must describe the suspect. You have to tell us who are you going to be looking for, so that you don't just pick anyone. You have to tell us that I'm going to look for a tall person or a very short person or a light-skinned person with some bald head, or I'm going to look for a lady that is looking like this. So that when you finally pick them from the line, we will refer to your statement and know that indeed the person that you described is the person that you picked. But if you're not able to describe that person for us, then there is no need of us going to the ID parade, because you are going to guess. Okay? And then, of course, lastly is the question of when the suspect and the witness have already met before the ID parade. So the rule is they should not interact. So if the witness has already seen the suspect before the ID parade, then there's no ID parade. Okay, so that is the rule. The other thing is, what do you think are some of the rights of the suspect? Now remember that at this stage is a suspect, is being suspected. Until the charge is read, is still a suspect. Okay, so what are some of the rights of a suspect during the ID parade? The first one, they have a right to consent. They have a right to consent. Okay, they have a right to give consent to participate in the ID parade. Number two, they have the right to be informed of the ID parade. So let's start with that one. So the first right is that they have a right to be informed that there's an ID parade. Lazima waambiwe, we are going to have an ID parade tomorrow. So they have to be told that you have a right to ID parade. You have a right, sorry, there's going to be an ID parade that is scheduled for, let's say, 7 p.m. or whatever time. There is going to be an ID parade. That is the first thing. The next one is that they have a right to consent to participate in that ID parade. They'll be told that you have a right to participate or not to participate. Okay. Thirdly, they have a right to bring an advocate or a friend. They have a right to bring an advocate or a friend. Are you together? They have a right to bring an advocate or a friend during the ID parade. So if they want to bring a friend, they need to bring a friend, which is also an issue. It is a problem. When you talk about reforms around ID parade, those are some of the things you need to talk about. Okay, so those are some of the rights of the suspect during ID parade. Now, what do you think should happen before the ID parade? Put up your hand. What do you think should happen before the ID parade? Quickly. Before the ID parade, guys, these are things you need to understand. You need to know them so that in case you get a question on ID parade, it has not been set for some time, by the way, some good time. It hasn't been set. Now, if you get a question asking you to prepare a brief on ID parade, you need to ask yourself the question that I'm already discussing. The first one is what happens before ID parade. The next thing is the rights of the suspect during ID parade. What happens before the ID parade, and during, and then after. Okay. All right, Priska.
What happens before the ID parade? The suspect should be informed of the reason why the ID parade is being conducted.
Yes, they have to be informed that there's an ID parade that is going to happen on this day at this time. Okay, so they have the right to be informed. Dagani.
The witness or the victim should give the police a description of the suspect.
Yes, you have to describe the person that you're looking for. It is not a guesswork thing. You have to tell us, who are you looking for? Who is it that you're going to be looking for? So you have to describe the person that you're going to be looking for. Okay, that is very, very important. Very, very important. The next thing, YT2, Paul. What do you think? Tell us.
I think inform the suspect of their rights. You know.
Complete that statement. Their right to eat.
From the
their right
suspect
to
of the
sleep.
rights, for example, the right to legal representation, the right to object, and then also explain this the whole process of the ID parade.
So they have to be told, informed of their right to say no, and the right to bring an advocate if they want, and the right to bring a friend if they want. That must happen before the ID parade. Yes, somebody called. I'm just seeing the normal faces. You guys don't want, the people that don't want to speak in this class. Okay, it's fine. Someone say something. Okay, Zaweria.
The police must get at least 8 people of similar physical attributes.
Yes, you have to get 8 people. If you can't get, and remember guys, don't participate in an ID parade for free. It is not for free. ID parade, these 8 people must be paid unless they are also suspects. Okay? Now, these 8 people are not suspects themselves. Okay? They're not supposed to be suspect themselves, but the police can use the suspect. Okay? So normally the police, they're supposed to go out on the street and find 8 people and pay them. There's an allowance for participating in the ID parade. So don't participate for free. There's money there. So I'm not saying you just go hoover around the police station expecting that something might happen and you might be called, you know. But just know when you participate, na pesa hapo. Okay, so they have to get 8 people. Yes, Alingo, Penina.
Mwalimu, this is, I'd like to try. The police officer conducting the ID parade should not be the investigating officer in that particular crime. Is it so?
Yes, the arresting officer, who is normally the IO, that is the investigating officer, should not participate in the ID parade. And the reason is very simple. If you're the arresting officer, you're the one who arrested the suspect. You should not participate in the ID parade because you already know the person that you arrested. And you might be able to influence the outcome of that case. So you are not supposed to participate. In fact, the OCS is supposed to appoint someone, another officer, to be in charge of the ID parade. Okay? All right. Yes. Anyone else? Rachel, you want to add something?
Oh, I don't know if it's been said. I was just going to add that the witness should not have interacted with the suspect before.
Yes. They should not interact. So if you go to the police station in the morning, stay in your corner and don't interact with the suspect before the ID parade. Okay? Those are the things that happen during ID parade. Guys, the examiner can set that question in a very twisted manner, but he's just asking you for those things that we are saying. Okay, Eric Owino. Okay. Now, let us go to the ID parade now. The parade is already lined up. What are some of the things that must happen during the ID parade? Yes, put up your hand. I hope you're taking notes. And I'm trying to move as slow as possible also. So what are some of the things that should happen during the ID parade when the line is already up? What do you do or what is supposed to happen? Yes, 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 yes. Some new faces, guys. You guys are so many in this class, but you're not saying nothing. What is wrong, my people? What is wrong, my people? Yes, Isaac Kimaru, number 1.
The suspect should be given an opportunity to choose the position where he would like to be placed on the line.
Yes, the suspect must be given the time and the opportunity to pick. We are 8. Where do you want to be? 1, 2, 3, 5, 6, or 7 or 8? Aha, that is the first one. Yusuf Noor.
The parade should be conducted in a neutral setting.
What do you mean in a neutral setting?
Like in a police station, where the
else?
witness can view the lineup without feeling pressured or intimidated.
I mean, where else would the ID parade be conducted if not the police station? Is there a possibility of it being at a non-neutral place? But yes, it should be in the police station, of course, because that also facilitates. Remember that if they were to have it somewhere, it's not, again, must be at the police station. Let's talk to Tracy.
The witness should touch the suspect in order to identify them.
Yeah, in terms of identification, it's either a touch or a point, but normally it's a touch, which is a problem again. You should identify the suspect by touching them, which is a problem. That is a problem that needs to be amended and that needs to be reformed. So some of the reforms around ID parade. So we'll discuss that in a minute. Something else, Priska?
The comments by the accused party must be recorded by the conductor.
Ngoja kwanza. Who is the accused party?
Sorry, the suspect. If the suspect makes any comments, then the conducting officer must ensure that they are recorded, especially if he's dissenting the procedure or something. They must be recorded.
The comments must be recorded. Yes. Mutinda read. Let me see your name. Redemptor. Okay. Mutinda Redemptor.
They must ensure that there's enough light. There is yeah.
We will come to that. The question of light is different, but of course you'd expect that ID parade will be conducted during the day, and I will explain to you why the lighting should not come at this stage. Okay. Wahoo, Caroline.
There must care should be taken to ensure that witnesses don't interact. If there's more than one witness, they don't interact when the parade is going on.
Yes, they should not interact during the parade. The witnesses are not supposed to interact. There's an ID parade that I participated in when I was in campus, and it was very flawed because all of us had agreed. We sat somewhere and agreed that this is the person we're going to point out, this one and that one. That is because these people had beaten us the previous night and taken everything from our small houses. So we are very mad. We're very, very mad. So we just, but anyway, if I was a lawyer at that time, I would challenge that ID parade process. I don't know whether those guys went to jail. I didn't follow up. So the rule is very simple. If you have to, and I don't think the police really take care of such circumstances, because if you have 10 witnesses that are trying to identify one person, normally the police will put you in one place, all of you in one place, and then they will be walking the suspect in front of you. So you guys know exactly that we are going to pick this one. So it's a process flow that the police need to arrange or fix. All right, that is a very important point. Dengue Alia.
Where the witness desires to see the accused or suspected person walk, hear him or her speak, see him or have a hat on or off, this shall be done, but in this event, the whole parade shall be asked to do likewise.
Yes, if you want the suspect to jump, they will all jump. If you want the suspect to sing, all of them will sing. Okay, that is the rule. Thank you very much. Paul Waititu. Paul Waititu. Redemptor Mutinda. One thing is still not said.
Unauthorized persons should be excluded.
Yes, unauthorized persons, unless you are authorized to be at the ID parade, you're not supposed to be there. I'm looking for something else. Thank you, Redemptor. That is a good point. Something else. Somebody want to say something? In terms of deformations? Yeah.
The police officers must not form part of the parade unless they are if they are accused.
Yes, they're not supposed to form part of the parade. Yes. Something about this. Yes, Kome. Thank you very much.
if the suspect has a visible mark, so the police then must ensure the others. It is either not visible or they find people who have certain similar marks.
Yes. If the witness has visible marks, some marks are visible. Also, if the suspect is coming from Western Kenya, they have very strong jawbones. So you have to make sure that you get people with very strong, so that it is not easy to gaze. Okay, but also you have to make sure that it is not apparent. Okay, if the person has a mark on the head, at least try to conceal it, because if the witness knows exactly that there's a mark at the head, he will go looking for it and he will find it. Don't make it too obvious for him. So let him find the mark. If this person has a mark on the arm, at least have some long-sleeved clothes. And if the witness is very sure that there's a mark, then he will ask this person to remove their shirt, and then they can see the mark on the hand. Okay, so that is what's supposed to happen during ID parade. And what happens after? Lastly now, what happens after? Quickly, what happens after the ID parade? What is supposed to happen after the ID parade? Quickly, guys. There are people that have not said anything. There are people that have not said anything. Try. Yes, Njoroge. Njoro.
Yes, after the parade has been concluded, the officer should ask the suspect if they are satisfied with how it was conducted, and his reply should be noted.
Yes, that is the comments of the suspect must be noted. They should be asked about their comments on the process, whether they're satisfied or not, and their answer should be noted specifically in the form P156. Diana Kipsuge. Kipsuge Diana.
Sorry, I'm saying form P156 is generated.
Okay.
And a report is made, and the suspect is informed that the report wouldn't be used to prejudice his case.
Yes, definitely you produce the report. I mean, you file a report, and from P156, which is done by the officer in charge of the parade, and that form is also going to form part of the documents in the police file. That form will be part of the documents in the police file. Okay, thank you very much. And then, of course, Paul, you have a question? Something to add? Yes, Paul?
Mine was just to say that the officer who, of course, conducted the ID parade should prepare a detailed report documenting the whole procedure. From it should have the date, the time, the location where it happened, the names, the details of the participants. Yeah.
Yes, thank you. So that is a report. And then, of course, you know that the suspect is not supposed to interact with the witness even after. They're not supposed to interact with the witness even after. So that is what happens during the ID parade. Now, we have talked about when the ID parade will not occur, what happens before, what happens during, and what happens after, and also the rights of the suspect during the ID parade. Now, let us talk about the admissibility of the ID parade, or the evidence that is generated from the ID parade. Now, for you to understand that, you need to understand two types of identifications. The first one is called doc identification and ID parade. Now, the doc identification is whereby the suspect is being identified, or the accused person is being identified before the court. That is where they will be asking the victim, can you see the person that assaulted you in court? Je, unamwona hapa? And then they'll be saying, ndio, mheshimiwa. and then ndakuuliza wapi, yako wapi yeye, ama yeye yako wapi. I don't know which one is grammatically Swahili correct. And then you'll be saying ndio yule amekaa pale. Okay, so that is dock identification. Why do we call it dock? Because the suspect is already on the dock. You can see him. The accused person is already standing on his dock, and chances of this victim saying a different person is very limited. So they'll just say him because he's just there alone. Okay, so that is dock identification. And then we have the ID parade that we have discussed. Now, ID parade will carry more weight than dock identification. ID parade will carry more weight than dock identification. Now, what are some of the considerations the court will make before admitting the evidence of ID parade? What are some of the considerations that the court will make before the court can admit the evidence of the ID parade? What are some of the considerations? The first one is the question of light. Okay? The question of light. And then the question of distance. Now, this is not light and distance in physics. I know some of you didn't do physics. Siarina history. So this is not light and distance in physics. It's just light, like light, and then distance, like distance. So what is it about light? And that's what I want to explain what Redemptor brought up. Now, in terms of identification, the suspect must clearly tell us what was the status and the nature of the lighting at the time of the commission of the offense. Guys, understand this. When we talk about lighting, we are not saying lighting during the ID parade. Of course, the ID parade will be conducted during the day. Okay? It is lighting during the commission of the offense. So we're asking you, what time did this person assault you? They assaulted me at night. Was there enough light at that time so that you can clearly say that I saw the person? Because if it was at night, then might be you didn't see the person. If you're assaulted in the dark, how sure are you that this is the person that assaulted me, the person that you've identified in the ID parade? How sure are you that they are the one that assaulted you? Okay, so you must clearly indicate and clearly submit and bring evidence or assure the court that that offense was committed during the day when lighting was proper, or it was conducted or committed at night, and at the time of the commission, the lighting was clear enough for you to see the person. If you're saying that the person came to your house and you saw them stealing something, the question is, when you saw them, was there enough light for you to identify them? That is the first one. The next one is distance. Now, this distance is what was the distance between you and this person at the time they were committing the offense. If you saw them stealing, where were you standing and where were they stealing from? So that you can see that if you're standing at least 500 meters from this person, then chances are you didn't see them properly. If it was 1 kilometer away, or if it is 400 meters, let's even say 400 meters. Okay, or no, not even 400 meters, even 300 meters is a long distance. Even 200 meters is a very long distance. So you, in terms of distance, you must actually indicate to us and tell the court that, hey, I saw this person. Okay, I saw this person. Somebody's saying something. I can't see anyone in the lobby. Nobody's in the lobby. So you might want to tell them to rejoin. I can't see anyone in the lobby. Yes, so tell them to rejoin. I can't see them in the lobby. Now, light is the lighting during the commission of offense. And then lastly, the question of distance. Distance is from the place you are and the person or the suspect. What was the distance? Was it a reasonable distance for you to claim that you saw them? Your human eye cannot see past some distance. So unless you're using some binoculars or something, you cannot say that you saw them. Okay, so that is light and distance. And then finally, what are some of the reforms? And this is the assignment I'm going to give you. What are some of the reforms around ID parade? What are some of the things that you think should be reformed around ID parade? The proposed reforms around ID parade. The first one is the question of witness protection. Witness protection. Now remember one right, that the suspect will have the right to bring their friends, to bring their relatives. Now their relatives will see you as a witness pointing at their friend, pointing at their brother, okay, as the person that committed the offense. And then you as the witness, you will use the same route that you came in with, and you'll share that route with these people. You can be compromised as a witness. They have seen you pointing their brother that is the one that committed the offense. They'll come for you. The next thing is a question of touching. So we need to rethink the whole thing about witness protection. At the same time, even the fact that you have to go and point this person and they're seeing you, that is a problem now. If they're seeing you, it is already a problem. Witness protection. Now, in other jurisdictions that are advanced, normally they use a one-way mirror. Okay, it's a one-way mirror. You can see the line. They have the numbers they're carrying in their hand. So you just say number 3, or you say number 4 or number 1. And if there's something you want them to do, you will say through the microphone and they will do that, but they can't see you. Okay, you just see them, but they can't see you. That makes sure that your right as a witness or your protection as a witness is concealed. Okay, your cover is not blown. At the same time, this idea of going to touch these people that committed the crime, assuming it was a sexual offense, this person committed a sexual offense and now you have to go and touch them again in a parade. It is crazy. So some of the things needs to be amended and be reformed so as to reflect the reality of life and some of the legal safeguards that we have. So you don't expect, if the offense that was committed is a grave offense and even of a sexual nature, how do you expect the victim of a sexual assault, for instance, to go and still touch the suspect that allegedly sexually assaulted them? So those are some of the things that we need to reform around ID parade, but there's more. So get the more. I've given you 2, 3 actually. Get the more. Are we together? So guys, that is the end of investigation. Now after that, the file is taken to the DPP, and the DPP will make a decision to charge or not to charge. From complaints, from introduction, jurisdiction, investigation, and ID parade. Any question? Any questions? So arrest, ID parade, preparation of files, we have condensed them into investigation. Yes, Namunyo Ndongi.
Yes, it's Kamunyu. Yeah, thank you.
Namunyo, sorry.
So is this entire process does it apply to minors as well, especially if they've undergone any traumatic event? How do you is there any sort of special arrangements that is above and beyond what you have already mentioned as a special, just to cater for that, maybe a minor?
Sadly, we don't. ID parade is just ID parade for us, everyone involved. But again, those are some of the things that we need to rethink. We need to rethink the entire aspect. It is not making sense even for adults, and it makes grave lack of sense for minors. So again, you would want to include that as one of the reforms that we seriously need for ID parades. Children will also have to identify these suspects the same way adults do. Are we together? All right, so I told you last week about a case that I told you to read about. I gave you the case of Michael Rotich versus Republic. It was a revision application to the High Court. And I told you, I gave you the subject, the context of that case. Guys, I know I've been very fast. Are we together? Like, have you understood what I've said? Up to where we are we together? Okay. So just understand the introduction bit of it. That includes the question to do with jurisdiction, the general principles of criminal law, and then the question of investigation, which involves somebody getting arrested, ID parade, okay, and then the entire question of preparation of files, the 3 types of files. Once you understand that, then the file will move to the DPP. But I want to mention something that I gave you a discussion about in the last class, that is section 36A, which is remand by court, which is on your screen. Now, I'm just going to give you a little context about this section and why it is very special and very important for you to understand. Okay. Now, what is important about this section is the case of Michael Rotich versus Republic. Michael Rotich versus Republic. So what happened to Michael Rotich versus Republic, or Michael Rotich? And in the last class, I told you that Michael was an athlete. Michael was an athlete. Michael Rotich went to to Rio, 2016, right? Yeah, 2016 Rio. So he went to Rio for the Olympics, and then he was accused of doping. And then once this guy was accused of doping, he was deported to Kenya. The moment he landed at JKIA, he was arrested. They took him to the magistrate court in Nairobi, and they told the magistrate that, hey, we don't want to charge him yet. We want to keep him as we do our investigation. That is the key word of the day. We don't want to charge him. We want to keep him for more days as we do our investigation. Okay? That is what they told the court. The magistrate agreed that Michael Rotich be held for a period, for an extended period, as the police completes their investigation. Okay? Now, Michael Rotich applied for revision. Remember that in criminal, we don't have appeals as interlocutory remedies. What do I mean? I mean, in civil, if an order has been made in the interim against you and you don't like it, you'll appeal it. Okay? You'll appeal it. If an interim order has been issued, you don't like it, you're going to appeal it. Now, in criminal, we don't have appeals on applications. And therefore, if you have a matter, then you have to apply for revision. So any challenge in as far as an order of the court is made, which is in the interim or interlocutory, then you have to apply for revision. So revision is how you deal with the interim orders before the magistrate. At the same time, how you deal with the final orders before the magistrate. Anyone who is confused? I don't want anyone to be confused. Please come, Manyale, ask your question.
When you say before the magistrate, you are meaning within the same court? Like you'll be revising, you go to the same magistrate who has made the decision or whatever orders, or you go to a higher.
Salimiwa. Huh? Have you ever been salimiwa?
Yeah, nilisalimiwa.
Okay, then kama umesalimiwa vizuri. So, were you in the last class? Were you in this class last time?
No, I was, but I didn't do the exam.
No, last week.
Pardon?
Last week.
Oh, last week, no, I didn't attend class.
Okay, you're excused. So remember we said that revision is a power of the High Court. It is a discretion, a jurisdiction of the High Court over the lower courts. So you can only apply for revision in the High Court. It is only the High Court that has the power to revise, and therefore what you're going to revise is the magistrate orders. Because if you are in the High Court, you cannot apply to the High Court to revise its own decision. The power of revision is only a power of the High Court, and therefore that power can only be exercised over subordinate courts. Okay, and that is what we said. So you can only revise a decision of the magistrate in the High Court. You cannot revise a decision of the High Court in the High Court itself. Neither can you revise a decision of the High Court in the Court of Appeal. Are we together?
So what do you do? The High Court.
About
what remedy do you have?
you appeal.
You appeal. Okay, thank you.
I'm having a feeling that we are still not on the same page. And I know that I'm opening a Pandora box into this question of revision, though it is something we're going to discuss later. But I'm feeling like there's a good number of people that are just keeping quiet and they're wondering, what did he say? So I'm not going to ask you direct questions. I'm just going to tell you, if you think, even remotely, that what I've said is not making sense to you, or it's not resonating, you're not understanding it yet, just put up your hand so that I won't call you. I'm just put up your hand so that I know, so that I can explain it. Because it is important for you to understand. Okay? Just put up your hand so that I can explain it. Okay. Now you can put your hand down. You guys are suffering in silence. Guys, one of the things you're going to learn is don't suffer in silence. Just say it. Whatever is disturbing your mind, just sema tu, mimi nayo sijakula siku tano, ama niko na shida ya. Don't, again, that applies in life generally. Just speak up. Don't die in silence. So this is what I'm saying, and I'm trying to explain it. I'm going to try and explain it in a very lay perspective. Okay. Now there are 3 remedies. Majorly, there are 2 remedies against. So let's start from civil. In civil, if you're before a civil court and a court has made an order that you don't like, there's certain things you can do. Okay. Number 1, you can appeal it. Number 2, you can apply for review. Okay. You can apply for review of that judgment. And also you can even apply for stay of execution. Okay. You can apply for stay of execution of that judgment if it is in civil. Okay. At the same time, assuming that you are in civil, okay, assuming that you are in civil, the matter is already proceeding and the court has issued an injunction against you and you don't like that injunction, normally you will appeal, because if I want an injunction in a court, I will make an application within the same suit and get an interim injunction order. Now, if you are the respondent and you don't like that interim injunction order, in civil, you appeal it or you apply for stay, but normally the way to overturn is to appeal it. Just appeal it. Okay? Just appeal it. Now, have the same example. If you're in criminal, you can't appeal it. Okay? Because we don't entertain interlocutory appeals in criminal. So in criminal, the only thing you can appeal is the final judgment. Any order that is given here and there, for instance, you have been denied bail. Okay? You have been denied bail. Or you made an application to be given an advocate, you've been denied an advocate. Okay, you wanted to have some evidence given to you, some documents delivered to you. The court has refused to give them to you. You made an application to be given someone from Nyamira akusaidie to translate. They have denied you. How do you deal with that? Now, in civil, if that was the case, you appeal. Now, in criminal, you can't appeal that. You apply for revision. Okay? You apply for revision if you are before the magistrate court. If you are in the high court, you can't even appeal it. You have to wait until the final order of the court and then you appeal the final order of the court. And that is as per the Delamere case. You know the Delamere case, Tom Chumonli, where the court said that, hey, the question of interlocutory appeals will only apply to this specific case alone. Now, that is where revision comes in. Now, revision is that emergency, ile emergency ya correct 1, 2 here and there, the emergency power of the High Court to correct a few things here and there so that we don't appeal. That is the power of revision. Now, the High Court is given the power to revise decisions of subordinate courts in criminal. It means at any time during the proceedings, during the case, if you feel like you are not happy with the finding of the magistrate court in a given order, whether that order is final or interlocutory, you can apply for revision to the High Court so that the High Court can revise that decision. Okay? Now, to make it easy for you, guys, anything that can be appealed can be revised. Anything that can be revised can be appealed. So we don't have specific things that can be appealed and specific things that can be revised. The difference is time. Any order that comes before the final judgment, you can't appeal it. Though you can appeal it, but the court won't accept that appeal. Okay? So any order that is made in the interim from the point a charge sheet has been presented and the accused person has been charged to the point before judgment, any order that comes in between, you can't go and appeal it in the High Court. If you're in the magistrate court, you can't go and appeal it in the High Court. However, the law allows you through section 362 to apply for revision. So revision allows you to do two things, okay? Revision allows you to do two things. The first thing revision will allow you to do is to challenge any interlocutory order in between. I've given examples. Bail. You have been denied bail by the magistrate court. Don't appeal in the High Court. Go and apply for revision in the High Court. Okay? You have been denied the opportunity to call a witness. So that ruling denying you the opportunity to call a witness, go and apply for revision. Don't appeal. You are calling a witness and they have refused. You are producing a document and they have refused. Or you want to reopen the matter and they have refused. Or they want to recall a witness. Don't appeal. Go and apply for revision. So revision is for two things. The first thing is any interim order, any order that the court makes in between that case, you revise it. That is the first one. Now, after the judgment has been made, after the court has passed the final judgment, you now have two options. The first option is now appeal is open. Number two, even revision is still open. So revision can be done in the interim and final, but appeal can only be done at the final. That is the cheat code when it comes to revision. Okay? We are saying, number one, appeals is only available in criminal. Appeals are only available after the final judgment. After judgment has been delivered, you can appeal the judgment because even section 350 of the CPC does not predict any appeal that is coming if not against the final judgment. And that's why 350 says you have to attach the copy of the judgment that you're challenging. So Normally, any order that is made by the court, which is not the final judgment, you don't appeal, apply for revision in the High Court. If you are in the High Court, then there's nothing for you. You have to wait until the case is done and then you can appeal. After the final judgment has been issued in the magistrate court, after the final judgment has been issued, at that moment, you now still have two options. Which two options? The first one is that now appeal is now open, you can appeal. At the same time, you can revise. So it is you are spoiled of choices. You can decide which one you want. All of them, they will be seeking the same power, the same remedy. You can appeal or you can revise. But also remember, the timeline is the same. If the time for appeal is over, you can't revise. So appealing and revision, they go at the same time, the same timeline, same ground, they're the same thing. Are you together? They're the same thing. So that is what I'm saying. So any interim order, revision. Final order, it can also be revision. But also when it comes to now the final order, when you want to distinguish between appeals and revision, because there are three things though, I'm not mentioning retrial intentionally because I know it will confuse you. I will mention retrial later in time. For now, just appeals and revision. Okay? So if you want to distinguish when do you appeal and when do you revise? I've already explained that. Number one, if it is an interim order, you are going to revise it. That is number one. Number two, if it is a final order, when do you revise it? You only revise it if it is a final order of the magistrate court. The final order of the High Court cannot be revised. I am talking too much, but I'm not very sure whether I'm being heard or I'm making sense. Are we together? Priska Monyale, your hand has been up ever since I started explaining. So I'm wondering whether what I'm saying is not getting home.
No, I have understood you. Though I just want just a small clarification. Assuming you've been, it's in an exam setting, and the fact patterns informs you that already the final order of the court has been issued. Then how do you decide as the best alternative when you're faced with both the appeal and the revision? Are there particular fact patterns or a particular desires of your client that may guide you to either go for a revision or go for a...
So let's do this.
Okay, so both of the
listen, let's not discuss that now because we are discussing revision even before we get to trial. It's going to confuse a lot of people. So I'm just giving the context. Sure. There are differences between appeals and revision. Of course, I've said this before, even in the last class, that appeals are pleadings. They are pleadings. Memorandums of appeal are pleadings. So they are pleadings and petitions. They are petition of appeal in the magistrate court and memorandum of appeal in the court of appeal. They are pleadings. Revisions are application. If the question says draft an application, that is revision. If the question say specifically prepare the pleadings, that is an appeal. At the same time, if the question uses the words that have been used in section 362, propriety, irregularity, legality, and correctness, those four words will mean revision. So when we get to revision, I will tell you when it is revision and when it is appeal. But right now, I've already told you when specifically it is revision, which is any interim order, so long as it is an order of the magistrate court. Okay, that is what I'm saying.
Thank you. Okay, thank you.
So let's go back in time and talk about what I wanted to talk about, which is whatever is on your screen. Time has really run out. So what is already on your screen, that is what I want to talk about. And I was giving the example. So this Michael Rotich went to the High Court and applied for revision because it was an interim order. The interim order was that it was not supposed to be released as the investigation proceeds. So that order of the magistrate, which is not a final order, now he proceeded to file for revision. And the High Court said, Justice Kimaru said that the police are supposed to have what we're calling a holding charge before they can hold you. They can keep you in custody as they do the investigation. This concept is familiar to everyone, that the police will arrest you and then they will say they want to do more investigation. So they want to keep you in the police cells as they do more investigation. You know that aspect. So when you see that question in an exam where your client has been arrested and they're saying they want to do more investigation, then that is a red flag and you need to advise your client as per section 36A. Are you together? So you of course you know that case again, repeated again in Oscar Sudi, engineer versus the national, of course versus the Republic, but through the National Integration and the National Cohesion and Integration Commission. I think that is the Caparo Commission. So when Oscar Sudi insulted allegedly the first lady, that is Mama Ngina, he was arrested, was taken to the magistrate court. They said, we want to keep this engineer inside as we do our investigation. And the magistrate said, yes, keep the engineer inside as you do your investigation. Engineer went to the High Court through revision in Nakuru. And then the High Court said the same thing, that you can't arrest without a holding charge and seek to have them in custody. So first go and investigate and have the holding charge, and then you can come and arrest. Now, that is important. Now, the next thing that is important is, how do you advise your client? How do you advise your client if your client is telling you? Because remember, in a criminal trial or in criminal, I failed to mention this at the beginning, but let me just mention it right now. In criminal cases, there are two people. There's the prosecutor and there's an accused person. Waiti Muhoro, put you down. There's the criminal side of it, which is now the prosecution and the accused person. So at all instances, you will be either for the prosecution, okay, or for the accused person. So ask yourself, which side are you representing? Whatever you'll be advising the prosecution to do might be different from what you'll advise the accused person to do. Are you together? So that is, you need to understand that bit. So even in this case, you can always get a question telling you that that like 2017 is a question. There's one question like that in 2017 is a question 4. If somebody has it, they can bring it to me and I can project it. Now, you're being told your client was arrested. Your client was arrested. They have been produced before the court on that day. You go to court and within the corridors of justice or corridors of the court, you hear that the prosecution are saying they are going to oppose bail and they are going to ask the court for more time so that they can do their investigation without charging your client. Now, the family of your client have come to you and they want an advice. Now, you advise them on what that is. That is remand by court. How somebody can be remanded by the court. Also, you can be told that you are now the DPP or you are advising the DPP. You are advising the DPP. They have arrested someone and they don't want to release him. They want to keep doing the investigation. How do you advise them? That is exactly also what is given under section 36A. Somebody should read. As somebody is preparing to read, Waiti, what is your question?
Oh, sorry. Yeah. So I was asking for the definition of a holding charge. What do you mean when you say that the prosecution must have a holding charge in order to continue holding somebody after the arrest?
There's nothing like definition of a holding charge. A holding charge is inferred from section 36A, which you are going to read right now. Can somebody read it? You read it yourself. You read for us yourself. Who is that? Wahoro Muhiti. Wahiti Muhoro. Read for us 36A, which is projected. What is remand by court? Guys, when you read this question or this section, please understand the procedure of holding someone or having somebody being remanded by the court. Read.
pursuant to Article 49(1)(f) and (g) of the Constitution. A police officer shall present a person who has been arrested in court within 24 hours after being arrested. Notwithstanding subsection 1, if a police officer has reasonable grounds to believe that
Are you tired? You're reading as if, have you eaten something today? Machoka sana.
Yes.
We need somebody who is very strong. Can you be strong? You're very tired, my friend.
Notwithstanding subsection 1, if a police officer has reasonable grounds to believe that the detention of a person arrested beyond the 24-hour period is necessary, the police officer shall A, produce the suspect before a court, and B, apply in writing to the court for an extension of time for holding the suspect in custody.
So just wait there. Let me explain that. So guys, first 36A, person to 491F and G of the Constitution, a police officer shall present a person who has been arrested in court within 24 hours. So if you're arrested, you must. So that is the starting point, that you need to be produced before the court within 24 hours. Okay, that is the first one. The next one, that is 2, says, notwithstanding subsection 1, if a police officer has reasonable grounds to believe that the detention of a person arrested beyond the 24-hour period is necessary, the police shall. So this is now the procedure of now holding someone beyond 24 hours. The first one, they shall produce the suspect before the court. The first thing they have to do is first bring the suspect before the court. You can't ask the court for more time if the suspect is not before the court. So bring the suspect before the court. Number 2, apply in writing to the court for an extension of time for holding the suspect in custody. So what am I saying? That first bring him before the court. Once you bring him before the court, make an application in writing, which is a notice of motion application and a supporting affidavit. Okay? You have to make that application before the court. And then in that application, of course, you have to indicate that you want an extension of time, and then you'll give us your grounds. Okay? Let's go to 3. Now 3 says that an application under subsection 2 shall be supported by an affidavit that is sworn by the police officer and shall specify the following things. Now this is where the holding charge is coming in. Waiti. This is where it is coming in. This is where we are getting the concept of holding charge. What are holding charges as defined in those 2 cases? What goes into a holding charge? There must be a holding charge. Okay? Now, guys, first understand the circumstance. What is the circumstance? The circumstance is very clear, and which is that at any point, you as the police officer, you want to detain someone for more than 24 hours. You first have to bring them before the court, because that order of remand can only be given by the court. That is the first one. The second one, once you bring them before the court, you have to make an application in writing, a notice of motion application and a supporting affidavit. Okay? And then that application and the affidavit must specify the following things. So the first one is the nature of the offense for which the suspect has been arrested. Why are you arresting this person? So a holding charge is like an incomplete charge, a substantive charge. Okay? Don't arrest me and take me to court and then tell the court that you are not sure of what you're charging me with, but you want to do more investigation. Hey, Jesus Christ. My grandfathers and my whatever are just following me like that. Huh? I need some serious prayers. Pastors in this class, please put me before the Lord. My villagers are not happy right now. Okay, so let's try again. Let's try again. So I'm saying you cannot arrest a person and then take them before the court. Once you take them before the court and you tell the court that you don't want to charge them, you are still doing your investigations. Okay? You don't want to charge them, or you don't know what you're charging them with. You want them to be held in custody as you conduct your investigations. Are you together? That is what you're saying. So you can't do that. So at least tell us what is this? What is the suspicion? Okay, what is this person being suspected of doing? So if you don't have that, then you don't have a holding charge. So there must be a holding charge, though it is not formally charged, but you already have it. Okay. For instance, when they arrested Sudi, they didn't have a holding charge. They are saying, oh, Sudi is trying to incite violence between Kikuyus and Kalenjins, and it's not a good thing. Oh, Kenyans, we don't want to go back to 2007. That is what they were saying. But they're not saying, fine, we are charging Sudi under this specific section. So you have to tell us, fine, you don't want to charge him now. But once you do your investigation, what do you think what do you think this person is going to be charged with? Okay, so that is what we are saying. So there must be a holding charge. First, indicating the nature of the offense. Number two, that this charge must indicate, this application must indicate the general nature of evidence on which the suspect has been arrested. What evidence has led you to arrest this suspect? What evidence do you have? So, guys, what is the nature of the offense? This will go into your grounds and they will go into your affidavit as you apply to for an order of remand by court. Okay. C, the inquiries that have been made by the police in relation to the offense and any further inquiries proposed to be made by the police. So, what is the nature of the offense? Okay. What evidence do you have so far? What is the nature of investigation that you have conducted? What is the nature of investigation that you're seeking to conduct? And then lastly, the reasons why you want to continue holding this person in custody. Why do you want to keep it in custody, though you've not done your investigations? Okay. And then, of course, lastly is in determining an application under subsection 2, the court shall consider any objection that the suspect may have in relation to the application, and the court may release the suspect unconditionally, just like Sudi was released unconditionally and Michael Rotich were released unconditionally. B, release the suspect subject on such conditions as the court may impose. Okay, so the court may have some conditions for the suspect. And then 5 says that a court shall not make an order for remand in custody of a suspect under subsection 5C unless there are compelling reasons, it is necessary for his protection, is serving a custodial sentence, have been arrested in relation to commission of an offense or has breached that condition. Okay. And lastly is that if the court makes that order, it will be for a period of not more than 30 days. So that is the application, guys. That is the application. It shall not be more than 30 days. And it can be extended. However, you know that under the Prevention of Terrorism Act, that is POTA, under that act, you can be held in custody for up to 90 days. So that act gives the prosecution or the police power to hold you in custody without any charge, for more than 90 days or up to 90 days. Now let us try and craft this application in our heads and say, fine, you're going to make this application. The first thing you're going to do is you present the person before the court, bring him before the court, and then make your application. So an application is just an application. A notice of motion is just a notice of motion. It will never change. What will change is the prayers and the ground. So what are the prayers? The first prayer is that the court do issue an order of remand, okay, or an order of custody demanding the suspect, which is the respondent in this case, in custody for You have to tell us how many days you want. Maybe for 20 more days pending investigation. And then prayer 2, cost. It's a simple thing. You just want an order holding this person in custody as you do your investigation. You can write it in whichever way. There's no specific way of writing these orders. There's no specific way of writing these orders. You can write them in whatever way that you want. So don't worry, don't stress. Okay, you can write them in whatever way that you want. So long as you are communicating that you want an order, the court do issue an order. You can say the court do issue an order remanding the suspect in custody for an additional, maybe for 14 more days or 20 days or 30 days, pending the completion of investigation. And then the cost, which is an obvious prayer, which application is further based on the following grounds. What are your grounds? Your grounds have been indicated in the act, in the CPC, and also they will be in the question. The first one is, what is the nature of the offense for which the person has been arrested? So you'll be saying this person has been arrested on the suspicion of committing a robbery with violence. Full stop. The general nature of evidence you've collected, that during the initial investigation, we have managed to recover maybe 3 pieces of items that were stolen from the same shop. And then you tell us inquiries that you've been able to make, that during the initial investigation, this is what we've done. We have been able to recover this and this, or make this application, or conduct some DNA, or whatever. And and then the final one is, what inquiries are you intending to make? You'll be saying that we are still we are planning to carry out a DNA test. We are planning to retrieve the witness statements from the victim's family. We are trying to maybe get the CCTV feeds, and then tell us why you don't want this person to be released in custody. From custody. And then you'll be saying maybe there are flight risks, same things as bail. There are flight risks. They'll interfere with evidence. We are trying to protect them. They will run away. They will interfere with the witnesses. They will commit another offense. So same grounds. Okay, same grounds. So just tell us this. So the beautiful thing with this is that all these things that I'm saying will be in the question. So it is easy for you to put down that application. So I want each of you to put down that application in your own words. Go to the grounds. Go to the prayers and the grounds. I will check it personally for you if you want to. Okay. So yesterday I told some people to do some things. I checked for them. Some did. That door of mercy is closed. Now we're dealing with this one now. So come up with that application. And I've said, guys, notice of motion is just a notice of motion. Okay. It will never change. What will change is just the prayers and the grounds. And the grounds are already in the CPC and they will be in the question. So craft the prayers and craft the grounds and then send me that application. I will check it for you so that you see whether you drafted the right thing. But also over and above, we shall draft it together also in class. So don't worry again, you don't have to stress yourself. We shall draft it. So guys, this is how you deal with remand by court. And I've said, what is the circumstance leading to remand by court? The circumstance is a person has been arrested. The police are not willing to let him go. Neither are they willing to charge him. What are they saying? They want to do more investigation. Now, in that instance, you can be appearing for both. You can be saying, for either. You could be the one for the prosecution. So therefore, you have to advise the prosecution on how they can get these more days for investigation. The other two is that you can be acting for the suspect. So in that instance, you have to advise the suspect on what really is the legal requirement when it comes to holding them in custody without a charge. It's as simple as that. So the first thing you want to do is first identify which question is this. Once you identify that the question is asking you about remand by court, everything else become easy. Guys, are we together? Now, I was to start on charges, but it's already time. We have 3 minutes past time. So I'm going to open the floor and take millions and millions of questions. I will take millions and millions of questions from where we started. But before we get to that point, I first want us to, no, we will close with the criminal procedure, because I've told you we will start with the criminal procedure and end with the criminal procedure. Why? Because it is very important for you to understand. Now, first, let us take questions that you have on these things that we've discussed today. Everything that you want to ask, please, please, please. I don't eat people. I only eat food. At least I know that. So don't be afraid. Just ask the question and then you get the answer. Okay. Meanwhile, put up your hand if you have a question. If we don't have a question, I want somebody to recite for us what the criminal procedure is. Now, if you've not written it down, write it down, put it down on paper, so that before you go to bed, always recite it. Always recite it. The same way with the civil procedure. Always recite the civil procedure. Where do you start from? Where do you end? Okay, so let's start with Foro Ahmed.
Yeah, thanks, Jacktone. Mine is on the DPP's file. I've seen in some cases these files take ages at the DPP before they're released. And when you asked, mnaambiwa the bado ziko recommendation. So I'm wondering, is there a legal time frame for this file? I mean, for how long this file can take at the DPP's office, or
No.
inakuwaga just delayed?
No. Remember, the DPP has the power to charge whoever they want to charge, whatever time they want. So that is their discretion. Ni hao tu watamua, hata wakisema ni 5 years ama 10 years, ni hao tu watamua. Huwezi enda kotini na useme hao watu wanachelewa sana. No. They will know. They will tell you, oh, we are still recommending. Maybe but wanangoja the brown envelope. Sometimes if it's a case that has political interest in it, they don't just run to court. They have to be given something small, either to prosecute or not to prosecute. So by saying we are still waiting for recommendation simply means bado hamjaongea vizuri. So bado tunaona recommendation ni gani hapa. Normally it's not supposed to take time. I mean, what are you're having a file for 5 years, file for 2 years. What are you doing on that file? Okay. So, but again, the constitution makes it very hard for you to demand it from them, because it is their power to decide whether they want to proceed or not. So if they don't proceed, that is on them. If they do, that is on them. But you can't force them to prosecute. If you think they're not prosecuting, then the law allows you to go and prosecute yourself. That is under private prosecution. So again, that is a balance of power that I think the law did not foresee, that the DPP can misuse their prosecutorial powers, which of course they do all the time. So there's nothing we can do about those files, my friend. We can just pray that things go well. Because Ahmed.
That is well noted, Jackson.
Okay, Kege, Anyanzo.
You asked on the criminal procedure.
No, before that,
I would wish to make an. Okay, sir.
Yes, let's just take a few questions and then you can make an attempt. I saw someone. Okay, guys, you guys mnaniangusha sana. But sawa, let me try and in the next 1 minute, let me try and summarize what I've said. So guys, we've said that in the last class we talked about general introduction and the things you're supposed to know about criminal law. I said look at the criminal procedure code, the CPC. I said look at the Evidence Act. Okay. I also say that you need to understand some of the things, some of the general principle of law that have been captured under Article 49 and Article 50. Now, those are the Constitution. That is the Constitution of Kenya. So you read that. Now, today we have talked about, or in the last class also we talked about jurisdiction. of courts, where we said that the court that has the last jurisdiction in criminal is the Court of Appeal, and the first court is the Magistrate Court. We discussed that. And then today, we completed investigation, though investigation we started last week. So arrest was part of investigation, and we have said that under investigation process, we have arrest, we have the question of ID parades, and we have preparation of files. So from arrest, from ID parade, we prepare files. That forms part of the entire investigation process. And then I've also mentioned something a little bit about decision to charge, where the DPP decides whether they want to charge or not, and it is their power 100% to decide whether they want to charge. Are we guys together? So that is what we've talked about. And also on completing the question of arrest, we have also discussed the question of remand by court, where under remand by court, I've indicated that there are certain times in question where you'll find you're being told that somebody has been arrested and the police are not willing to release them. The police is not willing to release them, and neither is the police willing to charge them. Now, based on that, essentially the police is saying we want more time. We want to take more time as we do our investigation. Now, if that is the case, then the procedure is well laid under under section 36A of the CPC, which is present the suspect before the court and then make an application in the notice of motion and the supporting affidavit. Once you do that, ask the court, number one, ask the court for an order of remand by court. And then for cost, what are the reasons? The reasons are simple. Number one, the charge, the suspicion, what the suspect is being arrested on, the evidence you've collected, the evidence you're willing to collect further, or you're going to collect further, and the reasons why you want to hold them, which you have indicated to be maybe they are a danger to themselves, a danger to the public, they will interfere with witnesses, they'll run away, and so on and so forth. And then you'll be given your orders if the court agrees with you, which is an order up to 30 days. Now that closes the first topic, the second topic, the third topic, the fourth topic, and the fifth topic. So we need to start on the sixth topic, which is charges and drafting of charges. It's a very interesting class that I wanted to read ahead, and so that when you come back, we will be drafting charge sheets and information, and all of you will be at par. Okay, now, as we close the class, somebody to give us what is the process, what is the criminal procedure. And we are saying that because I want you to understand when you start from point A, you need to know point Z. So somebody tell us, what is the criminal procedure? So we start with Anyanzo again. Anyanzo?
Okay, so allow me to make an attempt. The criminal procedure begins from when a complaint is filed.
Stop flipping those pages.
So it starts from a complaint, when a complaint is brought before the police. After a complaint is received by the police, then the next step is an investigation. And as from what you have seen, an investigation includes the preparation of the file, the arrest, as well as the ID parade. After that, this file is taken to the ODPP, where the ODPP, the Constitution mandates the ODPP with the decision to charge. Once the ODPP have found that there's a case to be answered, then the suspect is arraigned in court.
That is a gross violation of section 210 and 211. What do you mean? If the DPP finds what?
No. It's the DPP that makes the decision to charge. The other one, I apologize, that is after the prosecution's case. So it's the DPP that has to, the decision to charge. Then there's an arraignment, and I think you mentioned that is guided by Article 49F. And then there's a plea.
49(1)F.
49(1)F. Okay, then there's plea, the recording of the plea. Then there's the bail process. After the bail process, sorry?
Go back to what happens from arraignment. So tell us what arraignment is as we proceed.
Arraignment is the being presented before the court.
Okay.
When
Once you're
the
presented.
suspect is brought, the suspect is brought before the court, and then when they are brought before the court, that is when they are read out their charges, or like what you've just taken us through. The police can request for remand by court.
What is the stage there? What is the stage there?
It's still arraignment.
That's not arraignment.
Or taking of
They have
the
been
plea.
arraigned. Fine. They have been
Yes,
arraigned. They have been arraigned. Listen, they have been arraigned. Fine. Full stop. Arraignment is done. Next stage is
plea taking.
No, you can't go to plea. What are you pleading to?
Okay, then I request to be assisted from there.
No, come back. Nobody's assisting you. You're on your own. Let's speak it so that you understand.
Yes.
You've done very well. There's a complaint. There's investigation. It has been taken to the ODPP. They have decided to charge. Okay?
Yes.
There's arraignment. They've been arraigned before the court. When somebody has been arraigned before the court, do they just start when you're arraigned before the court? The moment umeingia hapo Anyanzo Kegei umeletwa na handcuffs. Ukifika tu kwa mlango hivi unaanza tu kuongea I'm not guilty or I'm guilty. Do you start pleading from the door?
No, the charges are read out.
Exactly. So the next stage is charges. You are charged. That is a serious stage that you can't go over. So you are charged. Once you are charged, then you plead to the charge. So you plead, which is a response to the charge. Tuko sawa?
Sawa.
Okay.
And then after plea, then the bail process.
Okay.
Once sorry.
Proceed.
I continue. Okay.
Yes.
So after the bail, the next stage now is preparation for hearing, which could include the pre-trial or proceeding to the hearing. After the hearing comes the sentencing.
Wait. Pre-trial and then what? Pre-trial and then what?
Pre-trial, then the hearing itself happens. Pre-trial, then trial.
Yes, you can't say pre-trial and then you say there's no trial. So pre-trial, which is before trial there's pre-trial. So that is why we call it pre-trial. So after pre-trial there's trial. And then after trial?
Then it's the court gives its decision, sentencing. There's judgment and then sentencing.
Which one comes first?
The judgment.
What are the two forms of judgment?
The court can either acquit or convict.
Yes. If you're acquitted,
you are discharged.
Where?
You are released.
Discharge and acquittal are different. If you're acquitted, you're acquitted.
You are released.
You are released.
And you are released. Then if the court convicts you, it sets another day for sentencing. Thereafter, after conviction is sentencing.
After conviction is sentence. Yes. After sentence, you go to jail. So that is the criminal process. Thank you. Now,
thank you.
We will discuss the trial process. There's a specific trial process that involves case to answer or no case to answer. We'll discuss it soon. But just on the basis of it, I want you to understand this as a lay person. On the basis of it, please understand that. Understand the criminal procedure. Where do you start from and where do you end at? That is what is more important. Okay, that is more important. It is going to help you. It's going to make your work easier when it comes to criminal. Guys, do you guys have a question so that we can adjourn? Any question? Last questions. Last. All right, sawa. So that is fine. So I will see you guys tomorrow for commercial. I will stop the recording, and again, like I've said before, please ask for the recording now.